we're here. We're here today in our case, CV17-0344, Dunn versus Fastmed. Each side will have 20 minutes to do their argument. Apparently, may reserve any portion of the time for rebuttal, but you're responsible for watching the clock with the clock up at the podium for that purpose. We are recording the argument, as I'm sure you heard me say earlier. The argument will be on YouTube in a couple of days, so you'll be able to see how you did. Because we're recording the argument, please identify your client and yourself when you begin your argument. We've read the briefs and the record. We've covered the case, so we're familiar with the facts and the law. So when you begin your argument, just go right to the points that you want us to know. Counsel, you may begin.
Thank you, Your Honors. May it please the Court. My name is Chad Hester. I represent the plaintiff appellant, Dr. Michael Dunn, in this matter. And as the Court has read the pleadings and the briefing before us, our issue here is we're here on appeal due to a dismissal of Dr. Dunn's case by the trial court, basically because of what the trial court found was a lack of improper venue of bringing this action. This is an action that began, as we know, due to post-employment obligations of Dr. Dunn that arose after he signed a separation agreement with the defendants.
Not the issue, though, is whether it's as a result of the post-employment obligations or as a result of the obligations arising from the transaction. That's the issue.
That's the issue in a nutshell.
You're characterizing it as the post-employment obligation. They're going to stand up and say, no, this is the transaction obligation.
Correct. And the issue here is, again, first and foremost, is this was brought on a motion to dismiss, and so we understand, as I understand the basic standards for a motion to dismiss, as opposed to summary judgment or something where an evidentiary hearing has taken place. This was to test the sufficiency of our complaint, our causes of action, and our claims, where we came to the court filing this action basically under the idea that under the separation agreement, the very last document signed and entered between the parties, is said that any and all disputes related to this employment obligation or any other interpretation thereof and agreements of any kind would be brought in Arizona.
I think that is an issue between the parties. And it seems to me that we only have two of the parties to the employment agreement, your client and Fastmed. But there are other parties with the earlier agreements that are not a party to the employment agreement.
Correct. They're not a party directly as far as executing the contract, but in the language of the separation agreement, you see that it's for the benefit of affiliated companies, and as we've discussed in our brief, the affiliated companies is defined in the second employment.
How does making an agreement for the benefit of third parties, which would give them standing to assert rights, how does that bind them? It gives them a standing to assert rights, but it doesn't bind them necessarily.
But those are the rights.
You're supporting the law for that.
Well, those are the rights that as we understand, that they are exercising when they
I enter an agreement between you and I and say, I'm going to give you widgets and you're going to give me $100,000, and say it's for the benefit of Judge Jones and bind him that way?
If it relates back to and including the agreements and the things that took place between, let's say previously Judge Jones and I had also been parties to an agreement, and that agreement conditioned employment and other issues, and it says it's for the benefits. They have, Judge Jones has a right to come and enforce against me, correct?
Right.
by the same token, that's what happened is we received the
You've
letter.
agreed to that. You've agreed that it's for the benefit of him by signing that agreement. He hasn't agreed to provide you the widgets.
Well, with all due respect, on the agreement, it doesn't say who, for example, Kyle Bohannon was even signing on behalf of. It says he entered it on.
Does that not create some heartburn for you, counsel? That the benefits are being waived for people who aren't participating in the action that results in the waiver, the alleged waiver?
Well, I guess we come back to what benefits are being waived. And by the same token, when you look at from Dr. Dunn's perspective, he understood that he had an agreement that he had been discussing with these people all along, saying if we follow the agreements backwards, we're going to go from and we're not here again on the issues of whether or not 5 years versus 6 months. This is, so we don't, the issues haven't even been developed in this case. This is strictly about, was venue here in Arizona appropriate for Dr. Dunn to bring the claim?
And in getting to that, I'm sorry, counsel. Go ahead. Please.
Anyway, so he brings the claim here in Arizona under his understanding, under an agreement he has signed with Fastmed, including Infor, and on behalf of his affiliates and all these other companies who are also parties to other agreements, who had rights that only the buyer, capital B buyer, could amend. And that's, the capital B buyers of Fastmed Urgent Care LLC that continued through each of these things, who, as we understand, from Dr. Dunn's perspective, Mr. Bohannon was representing all of their interests when he continued to negotiate and discuss each of these transactions at issue in the case.
But we have to look at the identified parties to at least the way I'm looking at. That's the first thing we need to look at. Who are the identified parties to the contracts? And it seems to me there is not an identity of parties between the second agreement and the original greater agreement. And whether Fastmed is operating on behalf of them or for the benefit, the benefited parties are not parties to that employment agreement. So I don't understand how they've waived their rights under the larger agreement because they weren't parties to the secondary agreement.
Your Honor, I understand where your question is coming from, but by the same token, we also have an issue that we do know that an agreement was issued and the very same person brought claims to say, hey, you can't work for Banner Health because you have a post-employment obligation to us. And that is Fastmed.
Is this a payback then? I mean, is it because they did this, then we get to do this extraordinary thing over here? I don't understand.
I'm sorry, payback between who?
Well, now you're bringing in the fact that Mr. Dunn should be able to say, well, gosh, look, I've suffered this, so you should suffer that. I mean, that's what I hear you say.
No, I apologize. That's not what we're saying is a payback or a tit for tat. According to our complaint, and again, Dr. Dunn understood that under his post-employment obligations, he had a 6-month separation agreement. So what we're not saying a tit for tat as to, it was his understanding, and that's the issues here is what is, number one, what is his understanding and belief as to when he brought this lawsuit? Was he entitled to bring it in Arizona under the last agreement he signed? Was he entitled to, or was it go back to Delaware?
Let me jump in, finish one question. I mean, it probably won't finish, but it sounds good going in. How's that? So your client's premise is that the separation agreement, and I believe I'm accurate in the word I'm using, superseded the previous agreements. Is that correct? Correct. Okay. Now, it didn't supersede a particular aspect or component or provision. It superseded. And can you define supersede for us just so I'm not missing the point on this? What does supersede mean in this context?
In this context is under the post, we'll call it the separation agreement, it specifically said unless it's otherwise contained, the terms are going to carry forward from the second employment restate operating
because it's specifically incorporated
those. And then it says unless it's changed here, all of those terms remain, and that's where we got into 6 months because it went from 5 years to 6 months. That's our contention. But in the second employment, it said any issues brought related to employment in that second one was to be brought in Delaware. It changed to Arizona. Okay.
Did Mr. Dunn repay the $1 million when he entered into the separation agreement?
No.
Because he thought he was still entitled to that money under the LOT, right?
His shares and his interests have been bought out, correct?
But now the LOT's been superseded, so he should get his shares and interests back and repay the $1 million.
Well, the entire LOT hasn't been superseded. The terms,
But you're arguing that your supersession language and the integration language in the separation agreement supersedes all prior agreements.
with respect to the subjects and the issues in the case, and
So you concede then it's only regarding the subjects and issues.
which is his future employment. That's our contention. Is dealing with whether or not he can, in plain terms, can Mr. Dunn go and seek employment in 6 months under one agreement, or does he have to wait 5 years under another agreement, even though?
Couldn't both of those stand alone?
I don't believe so, and for reasons that.
Well, one of them runs from the date his employment with Fastmed terminates.
Right.
The separation agreement says 6 months from the termination of your employment.
Mm-hmm.
The LOT, incorporating the purchase agreement, which is your separate issue, which I want to talk about too, says from the date of the transaction, right?
Correct.
So it's not tied to employment, it's tied from the transaction.
Right. But the same.
But it's not a post-employment obligation. We have one post-employment obligation that stands alone, which could theoretically go, it could be, we could be here, if he hadn't quit, we could be here 15 years from now arguing whether that 6 month period is run, long after the LOT had expired, correct?
Right.
Okay.
But again, to that point, Your Honor, is, and it has been spelled out in our complaint, the buyer, the capital B buyer, had an opportunity and was able to amend. He was the only one, we'll call it he, the buyer, capital B buyer, was the only person who could change the terms of how, the time for the non-compete and non-solicitation under the LOT. Keeping in mind that the LOT was never negotiated, or excuse me, not the LOT, but the LOT, the purchase agreement, was never even shown to Dr. Dunn until after we filed this lawsuit. Was
the buyer, as you term it, a party to the employment agreement?
Yeah, it's the affiliated company that's also, as we argue, included in and part of, because it's being signed on behalf of and entered in on behalf of each of those people. It's not just for the benefit of, if you look at the language, it's entered in on behalf of them. And that's the representations that are made, that's the language that's being used.
But it may be entered into benefit them, but if they aren't a party to the agreement itself, how are they bound?
Excuse me, I'm sorry.
If the agreement between two parties may be entered into for the benefit of a third party, but how is that third party bound if the third party is not a party to the agreement?
Well, and our contention is, again, testing the sufficiency of the complaint. Our allegations are it's also by and in between and on behalf of. That's one of the issues we have with Judge Udall's ruling to begin with, is this is not a decision to be based on the merits. Everything that we're talking about really goes to the merits of the case, as opposed to testing whether or not, based on our complaint, assuming the facts and allegations is true, does Dr. Dunn have a right to bring a cause of action in Arizona to have a determination as to what are his post-employment obligations? Does he have that right or does he not? The language is clear in the separation agreement that Arizona is the form that has been agreed to.
Between whom?
Between... I know we've got this briefed out for you.
I can tell you what the separation
well, I know
I've
got it here. It's Fastmed PC, and then for the benefit of the affiliated companies. You and the company, for the benefit of the affiliated companies, and these people have agreed to the following terms. So
the affiliated parties are a party to this underlying agreement.
Correct. By the same token, on the second employment one. Go ahead. I heard your question. Stop. Whereas the company, for the benefit of the affiliated companies, have agreed to amend, restate, and supersede all prior agreements. That's in the second agreement. So our contention is each of these affiliated companies are, in a sense, becoming beneficiaries and parties to this document.
But it doesn't say you and the company and the affiliated companies. It says you and the company for the benefit of the affiliated companies have agreed to the following terms.
Correct.
Okay. And would you agree with me, and maybe not, and I'm not trying to hold you to anything, under 12b-6, a trial judge is allowed to look at the terms of the contract and doesn't have to accept your allegations as to who's being bound, but can actually look at the contract and make a determination of interpretation as to whether someone's bound or not, right?
Yeah, he has a right to look at the contract and determine at least who is bound.
Right.
But again, here we have a wholesale dismissal on behalf of everyone, including the PC. Okay.
Your fallback position then would be, at most, he should have only dismissed Fastmed.
Yeah, I mean, we don't believe you should dismiss anybody. But having said that, at a minimum, Fastmed PC is going to be here, and then we should have a right to continue to pursue, again, additional discovery, disclosure. There's a whole lot of issues that have been raised in a motion to dismiss that really are more subject and akin to an evidentiary hearing, issues regarding intents of parties, what was going on, the nature of the history. There's a lot of things that are absent from the record, and that's why motions to dismiss are really limited to, let's test the sufficiency of the complaint and see, does he have a basis to bring this case in Arizona or doesn't he?
Well, I want to talk a little bit about your argument in the brief about the whether he should have even considered, the trial judge should have even considered.
I've got about 5.5 minutes. I'm going to reserve a little bit of time, but
go ahead. So whether the trial judge was even allowed to look to the forum selection clause in the purchase agreement. So talk to me about that. What's your best support for that proposition that he should not have looked at that?
That it wasn't the most recent, you follow the chain of events.
Now, you argue that he erred under 12b-6 and even considering the purchase agreement because you did not attach it to your complaint. Or are you not pursuing that argument anymore?
We didn't attach it because we didn't have it.
Right, but you made the argument in your brief that it was error for him to consider what was in the purchase agreement, both because it was superseded and because it wasn't part of your complaint, and that he was basically looking outside the four corners.
I think if it's looking at the four corners for purposes of understanding the overall parties and what's going on and who's going to go on, and I'm going to reserve 4 minutes, but I may go over answering your questions. He had the opportunity to look beyond.
I'll give you an extra 30 seconds.
Okay. He had the opportunity to look at other things that were presented to the extent they help understand the parties, but what he's done is he's gone beyond that. By doing that, he's said, this is the only agreement that matters. None of these other agreements matter, even though we have a case where Fastmed is basically saying you can't work in Arizona you have to bring your cases in Delaware, which consequently is going to create a huge burden on any person where the parties, the issue, the geographic, everything that we're trying to enforce on both sides, we're all going to run back to Delaware. I mean, it's designed to create a burden, an unreasonable burden.
That forum selection clause wasn't a surprise to you, right? Because you had that same one in your second employment agreement, and then you dropped it in the separation agreement. So it can't be that you claim you weren't given the purchase agreement, but he knew that there was this.
But according to the
clause.
allegations, Your Honor, with all due respect, according to the allegations of what he understood at the time, and this is again things that we flushed out through intent and understanding, there was a lot of discussions that were also incorporated in, such that why was the 5 years reduced to 6 months in our opinion? That was a discussion between Mr. Bohannon and things, and that's why you have an incorporation clause.
But the second employment agreement had the same forum selection clause as
Delaware,
as the purchase agreement.
And then when he left, it was also a discussion, are we going to have to do Delaware, or are we going to go to Arizona? And that's the issue we have is all along, Dr. Dunn has been led to understand it's only going to be 6 months, it's only going to be in Arizona, and that was the last thing he heard is it's 6 months, it's Arizona. He honored his commitment under that agreement by waiting nearly a year before he sought new employment.
But we have to rely on paroled evidence to get there.
Correct, which is not, and it goes both ways on the interpretation back to whether or not which contract is ultimately going to control. I'm going to reserve the remainder of my time, Your Honor.
I'll give you an extra 30 seconds.
Thank you.
With your permission.
Yeah, we'll add that.
We'll vote later.
Good morning, Your Honors. My name is Andy Federhar, and along with Jessica Gale, we represent Fastmed. Thank you for the opportunity to come today to talk to you. I think from your questions, you have properly distilled the two big issues. There are a couple of peripheral issues I'd like to talk about as well that involve this case. First of all is how you analyze the case. What's your standard? What do you look at? What are the presumptions? And then secondly, let's get to talking about the contracts and the documents that were part of the record, and they all were part of the record, as I'll talk about in a few minutes, and analyze whether Judge Udall, the trial judge, properly did an analysis, which is a question of law for the trial judge to do, about what these contracts said, who were the parties to them, which contract governed and which one didn't. First of all, Your Honor, the questions here today are not about venue. Dr. Dunn continually phrases this as if it's a venue case. This is a case about forum selection clauses and whether a forum selection clause is enforced for Arizona or for Delaware. That necessarily implicates which agreement you're going to look at. But you don't analyze this case under venue principles. You analyze this under forum selection principles. Early on in the pleadings before this court, in the briefs before this court, appellant raised the issue of whether this is a 12b3 or a 12b6 analysis. When we pointed out in response that, well, that's really a difference it's a distinction without a difference, and in fact, if appellant is correct in applying a Rule 12b3 standard, all of his arguments fall away. Because under 12b3, in cases outside of Arizona, we weren't able to find one in Arizona, you look at the facts and you don't give them any credence, and you're allowed to supplement the record. Under 12b6, of course, you don't do those things. So you'll note that in the reply brief, plaintiffs or appellants seem to have dropped that argument. So I'm going to focus on 12b6 analysis here today because I think that's what the appellant has basically conceded to, despite having spent a substantial portion of his opening brief talking about something else. Let's talk about what was in front of the trial judge and properly in front of the trial judge, and let's talk about what's not in the record. You just heard a few minutes ago that Dr. Dunn didn't have the purchase agreement at the time that he signed the letter of transmittal. There's nothing in the record that supports that. That's not contained in the verified complaint that's been filed in this court. In fact, when you read the letter of transmittal, which was attached to the plaintiff's verified complaint, it makes numerous references to the purchase agreement. When you read the appellant's verified complaint in 3 separate paragraphs, I believe it was 18, 22, and 23, he talks about the purchase agreement. So to come before Your Honors today and say that he didn't have a copy of the purchase agreement, even if true, he was certainly aware of it. It's certainly a central issue in the case. It's referenced in his verified complaint. The trial court properly considered it.
Had it been executed at that time?
Yes, it had, Your Honor. It was executed.
It executed it, but he didn't have a copy of it.
Yeah.
I'm just wanting to get
he
the facts
was not a
straight.
signatory to the purchase agreement.
He was not a signatory to the purchase agreement, but when he signed the letter of transmittal, it was attached as Exhibit B to the letter of transmittal.
And the letter of transmittal specifically says, I agree to be bound by the terms of the purchase.
Absolutely correct, Your Honor. Absolutely correct. So even if he didn't have it, he should have, because he signs disclaimers in the letter of transmittal that he's not relying on anything, and he signed an agreement that says, I have a copy of this, and it's attached as Exhibit B. So I just think that's a side issue, Your Honor. So the question becomes, how do you interpret, then, under Rule 12b6 standards, how do you interpret the various agreements and read them in a way that gives meaning to all of the contracts? Because after all, I mean, I can't imagine how many cases you have in front of you where you're asked to legally interpret a contract. The principle is you want to give meaning to every phrase and every contract in a way that they're not contradictory to each other. And I know I'm simplifying that standard, but I think that's the accurate standard by which you look at contracts. So let's take a look at the separation agreement. Now, you were told a couple of things on opening comments that I just are patently not true, and I hate to say that. The separation agreement clearly delineates who Kyle Bohannon was signing on behalf of. Kyle Bohannon at the time was the president and chief executive officer of Fastmed Urgent Care PC, and that's defined as the company in the opening paragraph. When you go back and you look at his signature, it's Kyle Bohannon, president and chief executive officer. Then the phrase is, for the benefit of the affiliated companies, and that's kind of the nub of this. That's what Judge Morris was focusing in on. I think that's kind of the nub of it. The argument that appellants make is that once you sign for the benefit of somebody, that person becomes a signatory to the agreement. And that makes absolutely no sense. It makes no sense in this agreement specifically because in paragraph 11, the general terms provision that contains this clause that appellant is focusing on, there's another provision called third-party beneficiaries. And what that provision says in paragraph 11 is each member of the company group, other than the company, in other words, all the affiliated folks, are express intended third-party beneficiaries of this separation agreement and shall be entitled to enforce any provision hereof. If you accept appellant's argument, that language is not necessary, because under Dr. Dunn's argument, there are already parties to this agreement. And so his argument renders the third-party beneficiary language, it renders for the benefit of the affiliated company language, it renders that language meaningless. And so you should never interpret a contract in a way that renders provisions of it meaningless. In his opening brief, Dr. Dunn acknowledges that you look to this preamble, the first two paragraphs, to help you with determining what the intent of the contract was. Now, taking a step back, neither party contends that any contract in this matter was ambiguous. Neither party in this matter contends that there are any additional facts that you need to interpret. I heard parole evidence at the end of appellant's opening presentation, but there's never been any allegation that there were additional facts that should have been presented to the trial court before he made his decision. So you're left with the four corners of the document, and as an appellate court, you review the meaning of those contracts de novo. So you're entitled to take a look at what those contracts mean. So let's do that for a few minutes today. When you look at the first paragraph in the preamble, what does the very first sentence say? This letter agreement, the separation agreement, follows up on our recent discussions concerning the settlement of matters relating to the end of your employment with Fastmed Urgent Care PC, a North Carolina professional corporation, the company, for the benefit of the affiliated companies. So that's the purpose of this agreement. It's to end his employment. And when you read the agreement, everything in there is about his employment. What are his benefits? What does he get when he's severance? What happens to his stock options? How long does he get paid? What's his non-compete for the time period following his employment? Which is not necessarily, as Judge Morris pointed out, coterminous with the 5-year non-compete found in the purchase agreement and the letter of transmittal. So the two don't necessarily run at the same time. If he had stayed employed for longer, that would have been an additional 6 months on top of the by then expired 5-year time period.
So if the parties to that agreement had a dispute that did not implicate the purchase agreement or the letter of transmittal, then the terms of that contract would govern. And I want to say the name absolutely correctly, Your Honor, if Fastmed Urgent Care PC, a North Carolina professional corporation, had a dispute with Dr. Dunn, it would have been decided under the forum selection clause of the separation agreement related to the terms of his separation. If, however, the parties had a disagreement over the terms of the purchase agreement or the letter of transmittal, that would still be governed by those two documents and not this one.
But Mr. Dunn's the one who filed the deck action, right, in this case?
Oh, no. He's filed a lot more than that.
But he's the one who initiated the complaint.
Correct.
Okay. So he filed challenging the separation agreement, whether the separation agreement fine. Why would the court dismiss that case? It seems like that case should go on, and you guys should be able to file separately a deck action in Delaware or some type of action in Delaware saying, hey, we want to enforce this agreement. So I'm a little hung up on, even if both these agreements survive, why would the court be allowed to dismiss his action where he's only alleging that the separation agreement is?
Because his allegation is that the separation agreement superseded the purchase agreement. And whether it's explicitly or implicitly stated, that's the nub of what his argument is.
And counsel, can you address for us, when we use the word superseding, did it?
Replaces.
Huh?
Replaces.
Okay. Is it, as I believe I understood counsel to say, is it as to paragraphs 1, 3, 7, and 9, or is it simply this replaces that?
Let me, I always find it's better at my age in life, Your Honor, to read the words as opposed to trying to remember them correctly. So let me...
Fair counsel.
Let me get to paragraph 11B in the separation agreement. And it's just 2 sentences.
No. I think what he's asking is what's his allegation in the complaint? Did he allege that the separation agreement superseded the entirety of the separation of the purchase agreement? Or?
To the extent that there were conflicting terms. So there were terms in the separation agreement.
So his allegation and complaint is that it only superseded the language of the form selection and non-competition provisions.
Correct. I believe that's correct, Your Honor. I don't think he's contending that it did away with all the obligations of the purchase agreement about getting $1 million, transferring your stock, and things like that.
Right. So then he is, and I guess I should ask him this when you get back up. He's not arguing a plain language, because the plain language of that integration clause in the separation agreement supersedes all prior agreements. So even he isn't really arguing that we should just apply that and not look to anything else.
Well, and so, Your Honor, again, that argument, I believe, supports our position in this case. Because if you look at the plain language, as Dr. Dunn argues it, this paragraph would take precedence over everything. But it clearly doesn't, and it can't, because there's no, aside from the lack of consideration and everything else that's kind of missing, there is no unity of parties. As the court, delved into during your direct examination or direct questioning of counsel. The only parties to this document are Fastmed, Urgent Care PC, and Dr. Dunn. Now, FastCare was acting for the benefit of third parties, but the purchase agreement in paragraph 14.04, I believe, says that if any change, any amendment is made to the terms of the purchase agreement, it has to be signed by the party who's waiving that right. And so that's why this question of who signed what becomes so critical. And so because nobody but Fastmed, Urgent Care PC signed the separation agreement, all of the other signatories have not consented to a waiver of their 5-year non-compete.
Well, let's talk just about Fastmed then. So maybe the trial court erred in dismissing, or erred to the extent it dismissed Fastmed, but not everyone else.
I don't think so, Your Honor, because, again, you have to look at what the purpose of the separation agreement was, and that's what the trial court did. The trial court looked to see whether that was the purpose, was to supersede the purchase agreement. And so the judge read the agreement, and he made a legal interpretation about what the scope of that agreement was, and we think he's correct.
Well, we're supposed to look to the intent of the parties, right?
Absolutely.
Okay. And you have Agreement A that says form selection Delaware and 5 years.
Yes.
And Agreement B says form selection Delaware in 6 months. And then Agreement C says form selection Arizona, 6 months. Why wouldn't that just tell us, at least as to that part, your client, Fastmed, has agreed that we're only talking 6 months in Arizona?
Because the separation agreement, by its own terms, applies only to the settlement of matters relating to the end of your employment with Fastmed Urgent Care. It does not apply to the purchase agreement and the letter of transmittal.
So the non-compete clause is not related to the terms of the employment between Mr. Dunn and Fastmed.
So let me kind of break it down two different ways, Your Honor. When you buy a business, you not only buy the business, you buy the goodwill of the business. And Dr. Dunn was the medical director. He was the guy going out and recruiting other doctors to come work for Fastmed or Urgent Care at the time and man their urgent care centers, which you see all over the valley. Right? So he had a lot of goodwill and reputation. He also had 1/300th of a share of the urgent care company that was being acquired by the entity that's now known as Fastmed. So you're buying two things. You're buying not only his share, but you're buying his goodwill. And if he was allowed to go out and compete immediately or a short time thereafter, the value of that goodwill is severely diminished. Now, let's transfer over now to simply an employment agreement. And as this court understands, non-competes are strictly enforced in an employment setting against the employer, but in a commercial transactional setting, there's a far more laissez-faire standard applied because it's an arm's length transaction with equal bargaining power. So under that loose enforcement, strict enforcement standard, Fastmed said, all right, for however long you're employed for us, which could be longer than the term of the 5-year non-compete. When you leave us, for 6 months you can't compete with us. Now, the fact that by happenstance he left before the end of the 5 years shouldn't really change the outcome of the case. There are two separate obligations, two separate sets of consideration, two separate sets of parties, and two separate limitations on Dr. Dunn's ability to go out and compete.
Why shouldn't we buy or accept Mr. Dunn's argument that under principles of construing things against the drafter, we should have forced you guys to say, by the way, this 6 months doesn't apply to the 5 years before?
Aside from the fact that the agreement says you shouldn't do that, and the parties agreed that there is no strict enforcement or no interpretation against the other, you don't need to get there, because that's a secondary principle of contract interpretation, Your Honor, and you only get to the secondary principles of contract interpretation if the document's not clear on its face. And this document, in its first paragraph, in its preamble, which, by the way, both parties agree you look to for intent, says this separation agreement deals with the end of your employment, period.
So what we're dealing with is what the scope of the separation agreement was versus the scope of the other agreements.
The scope of the separation agreement is far narrower than the scope of the letter of transmittal or the purchase agreement. Yes, Your Honor.
So your view is that what the rights and obligations are under the non-compete provisions of the purchase agreement and the letter of transmittal are not within that scope.
Correct, Your Honor. And the way I would put it is sort of as I did a few minutes ago. It's a happenstance that Dr. Dunn left employment within the 5-year non-compete period. If he had left after that time, we wouldn't be having this discussion, right? Because there only be the 6-month time period.
Or would they be arguing that it is subsumed within the 5 years and therefore it had run in the first 6 months?
Well, but the terms of the separation agreements or of the second employment agreement said 5 years from your termination date. Okay. So by its term, it would have covered that. But by the way, Your Honor, since you bring up the second restated employment agreement, in that document, they make a specific reference to the purchase agreement. They don't do that in the separation agreement, which I think is further proof that the parties intended something different. So what they're asking you to do is to take a general clause under the section called general terms and use it to supersede a very specifically negotiated and highly compensated payment because it doesn't fit what he wants to do today. He doesn't want to return the $1 million that he got as consideration for his goodwill and his agreement not to compete for 5 years as part of the sale. And he wants you to believe that this language that says for the benefit of somehow makes people who were not signatories signatories. And that's critical because under the purchase agreement, unless you sign a waiver, your rights can't be taken away from you. And there's clearly a right to a 5-year non-compete under the purchase agreement. That finding of fact by the trial court judge is sustainable based on the evidence. And part of that evidence is, as I stated earlier, when you read the document, the separation agreement, the way that Dr. Dunn wants you to, you have to read out of it for the benefit of and the third-party beneficiary clause. Because under Dr. Dunn's interpretation, those people are signatories and bound to the agreement. They're not benefited by it. They're not third-party beneficiaries of it. They're bound by it. And therefore, that language becomes superfluous. That's not the way you should interpret the agreements.
And to have altered that agreement, they would not just be bound by it, but to alter that agreement, they would have to agree to the alteration.
Correct, Your Honor. And they'd have to do it in writing. And that's what the terms of the purchase agreement and the letter of transmittal state.
Yeah, as I understand, and correct me if I misunderstand, Dunn asked for declaratory relief that the separation agreement superseded the earlier agreements. But I take I take your point that it doesn't supersede all of the agreement. But do you agree that he would be entitled to relief as to the narrow scope, as you call it, the narrow scope of the separation agreement?
I think he's entitled to relief as it relates to the separation agreement. But the separation agreement only relates to issues involving the end of his employment with Fastmed. The separation agreement does not deal with the 5-year covenant not to compete found in the letter of transmittal. And I think that's where your question, that's where I would like to take your question. To the extent that he brought a claim that would be covered by the separation agreement, that is to say you didn't pay me a benefit that was required to be paid, or you're trying to interfere with me after 6 months and the other 5-year provision no longer applies, then he could enforce his rights under the separation agreement. But in this circumstance, where he's seeking to enforce his right to the derogation of the existing rights under the purchase agreement, that he cannot do.
Thank you, counsel.
Thank you very much, Your Honors. We have asked that you affirm the trial court and award us our fees on appeal. Thank you.
And Mr. Keefe, if you'll add 30 seconds. Thank you. Counsel?
Thank you. Hopefully this will clear up. Exhibit G to our complaint was the letter that started this whole thing. It's the August 31st, 2016 letter sent to Banner Health, who was hiring Dr. Dunn. It was sent by Latham and Watkins, and I'll read from it. It's part of Exhibit Z. Dear Mr. Bixby, that's at Banner Health, we are counsel to Fastmed Urgent Care PC, together with its subsidiaries, affiliates, including without limitation Urgent Cares of American Holdings, Fastmed Holdings 1 LLC, and the respective subsidiaries assigns Fastmed. I'm kind of briefing the quote here. It then says, we understand he's accepted a position. The remainder of the letter says, we, Fastmed Urgent Care PC, are seeking to enforce the letter of transmittal. What have we talked about here all along? They're not a party to the letter of transmittal. They're not a party to the purchase agreement if you look at those documents. So what is going on? That's the whole issue that we really have here, and that's why the case is brought the way it is.
You're saying they didn't have standing to send the letter to Banner?
No, this is just a private letter, but what we're saying here...
But the assertion, is the assertion that is your assertion now that they didn't have any standing to object to Dunn going to work for...
If we understand, and again, if we understand what we just heard from counsel, if, according to him, if Fastmed Urgent Care PC was seeking to stop him, they would have sought to assert their rights under a separation agreement. They didn't do that. According to this letter, they're seeking to assert their rights under a letter transmittal that they're not a party to.
So Fastmed is not a party to the purchase agreement or the letter transmittal.
And that's the confusion here, Your Honors. There's no, I mean, I hate to say there's no clear answer who's on first and what's on second, but that's the issue that has been created here is essentially we have an issue regarding post-employment obligations that has been commingled and confused between a company that's not a party to letter transmittal coming in their very letters saying, you owe us 5 years of non-competition. Yet, we just heard from counsel, they would be enforcing under the separation agreement the calls for Arizona, and it's being done, of course, on the affiliates and the behalf of that we talk about, that they're seeking to assert those rights. Part of this case when we originally brought it was seeking an injunctive relief, which was dismissed by the court. But the same token was, the idea was, hold on, we need to figure out what's going on here because this thing is a commingled mess. And part of that is at some point getting through in the litigation and discovery, defining and figuring out who in fact is representing who and who in fact is benefiting what and what's going on. It's a mess.
Counsel, neither of you are new to this process. Mm-hmm. Didn't anybody sit down at the time that these documents were drafted, at the time they were prepared, at the time that the parties were delineated and say, who's that? Or no. Why do I owe them? Or how can they expect anything of me?
No, because, Your Honor, as it occurred, again, according to my client, it was brought to him, sign this, move on. Here's your letter transmittal, sign this, move on. Here it is, and we need to turn around. And you look at the timing of the dates of all these agreements. This was a very quick process, both with the merger agreement and the sale, where They came to him and said, here's a letter of transmittal, you need to sign it so we can release. At the same time, through Kyle Bohannon and others, they're saying you need to now re-enter a new employment agreement because part of the merge is we had to terminate your employment. And these are all interrelated and conditioned upon each other. The merger, part of the condition was maintaining him as a medical director.
In your brief, your opening brief, you allege Fastmed merger subs sold or merged their interest in the purchase agreement letter of transmittal to the appellees, which is Fastmed PC. So
That may be a little bit of, I hate to admit, sloppy writing, but.
okay.
I mean, and that's why I point you back to the Exhibit G.
Fastmed PC, at least as alleged, and I think your chart shows the same thing, that this is the surviving entity that was formed.
That's been our understanding so far. However, the merger, the problem, when I see I'm out of time, but I'll answer your question. And,
Please.
I'll let you know when you can go.
yeah. The whole thing, like, again, that started this was the idea that the PC was seeking to enforce something, and the confusion to Mr. Dunn, or Dr. Dunn is, but wait a minute, which agreement controls it?
Okay. But you also, in your reply, you acknowledge that there's at least some entities in the to the letter of transmittal that are not either affiliated companies or
correct. Two of them, I believe, have been as part of the merger, were either dissolved or just they removed from the ongoing company moving forward.
Right.
And these companies that remained, the affiliate subsidiaries, are the companies that are all seeking to enforce and stop Dr. Dunn from continuing to be employed as a medical director. And so
Thank you, counsel. We appreciate your argument.
Thank you.
We appreciate the arguments made today. We'll issue a decision in due course. We stand we stand in recess while the next case comes forward. I think we'll.
Yes.
Thank you.